Hi, how you doing? My name is Jack Price. I'm a professor of civil procedure at University of Richmond School of Law. My task right now is to help you tackle any joinder problem that comes along. Any joinder problem. You may not even know what the word joinder means. That's okay. Joinder is unfortunate. It's too complicated because all it means is join. But we're lawyers. We can't do anything as simple as it might be, so we add that D. Joinder just means join. Well, what are we joining? We're joining one of two things, either claims or parties. So here's how it works. A classic early, say the most primitive lawsuit of all time. One plaintiff sues one defendant for one claim. That's it. Things get a little more complicated, right? One plaintiff sues one defendant for two claims or three claims. There's a breach, there's a fraud, there's some sort of tort involved. Then you might have three claims, but you might have multiple defendants. One plaintiff brings three claims against three separate defendants. Then you have multiple plaintiffs joining in. Next thing you know, it's a veritable party. Multiple plaintiffs, multiple claims, multiple defendants. The federal rules are rather liberal, not unlimited, but they're rather liberal in when you can join all these separate claims or parties together into a single action. What I'm going to help you do is figure out a way to determine whether or not all these things can be grouped into one. The easiest way to do this is to separate out claims from parties. Okay? We're going to use a similar task in sorting it out, but let's start with claims. So the best thing to do, find a piece of scratch paper in the side of the book that you're working on or the test booklet or anything and diagram everything out. I can't tell you how much that'll help you. I do it all the time. Students come in and ask me questions. First thing I do is pull out scrap paper. I don't know if that makes me look not as sharp as I ought to, but I can't do it without scrap paper. I urge you to write it down. When you see these claims, you diagram them out with P's and D's and arrows. So that primitive case that I just explained to you, 1P versus 1D, you write P versus D, and then you write an arrow from the P over to the D. Okay, that's all you're doing. I want you to diagram it out. Every arrow is a claim. So, for instance, if there's P versus D and there's two claims, a breach of contract and a fraud claim, it's P versus D with two arrows. Suppose the defendant invites some third party to join the lawsuit. We'll talk about a little bit of that with Joinder of Parties, but the defendant invites some third party to join the lawsuit. That's another arrow over to the third party. Make sure there is an arrow for every claim. Okay, so once you've put the arrows out there, then you have to label the arrows. What am I talking about? Label the arrows. For every arrow, for claims that are joined, the federal rule uses a certain number of words to describe them. So, an ordinary claim, they just call a claim. Okay, that's boring. Other claims they call counterclaims, cross claims, impleter claims. Okay, so there's a couple different things going on here. So, for each arrow you label it. Again, the primitive suit, P versus D, one arrow going across. What do we call that? Just a straightforward claim. Okay? Suppose there's two arrows going across. Still one P, still one D, but two arrows. There, I want you to label that multiple claims. You can label the top one multiple, the bottom one multiple, but you need to acknowledge for yourself you've got multiple claims. Okay? Suppose that in this particular lawsuit, P sues D, but then D fires back a counterclaim. That arrow going back from the defendant to the plaintiff. I want you to write a label on that says counterclaim. Okay? Suppose that a third party is brought in from outside. P versus D versus another D. The arrow going to that extra D, call that an impleter claim. So you want to label all of these. The one claim that I haven't mentioned yet is a cross claim. Suppose plaintiff sues two defendants. Two people have caused me harm, not just one. I'm suing them both. Then they decide to start suing each other. That's called a cross claim. So you've got a map of the lawsuit, each claim represented by an arrow, and each claim labeled as either a multiple claim, or if it's the only claim, not labeled at all except just claim, or labeled impleter claim or cross claim or counterclaim. Once you've got it labeled, then you apply your rules. the rules for whether or not you can bring a multiple claim, a counterclaim, a cross claim, or an impleader claim. So let's work through those real quick. First thing, the most basic claim, you can bring a claim. Guess what? That's no surprise from the federal rules. You can bring a single claim. What about multiple claims? 1P versus 1D, but 5 or 6 different arrows running from the plaintiff to the defendant. Can you do that? Absolutely. If a client ever asks you, I have 25 different things I want to sue the defendant for, can I do it? Yes. You don't even need to think. Someone might be tempted to say, but are those related to each other? Doesn't matter. The rules say you can bring as many claims as you want regardless of whether they're related. Now, if you leave related claims off that multiple claims list, you may suffer some preclusion problems later, but that's not what we're going to get into right here. So, multiple claims, the rule is if you got them, you can bring them, no problem. It's an open door. So what about counterclaims? That's the arrow going back from the defendant to the plaintiff. Counterclaims are also permissible. If a client ever says to you, can I bring a counterclaim? You can say yes without even thinking further. And the defendant will say, but you don't even know what the claim is. You say, I don't need to know. The federal rules say you can always bring a counterclaim if you want to. Now, that is the law of joinder, I'll note as an asterisk right here. That's the law of joinder. Doesn't mean you have subject matter jurisdiction. You always need to figure that out separately. But as the law of joinder is concerned, you can absolutely bring that counterclaim. But for counterclaims, there are certain instances where you must bring a counterclaim. That's called a compulsory counterclaim. If P sues D and D has a claim arising out of the same transaction or occurrence that is the subject matter of the plaintiff's suit, the defendant has to bring a counterclaim or else forfeit it for all time. So if the client asks you, can I bring a counterclaim? Your answer should be not only can you, but sometimes you must. Okay, sometimes you must. So let's move to the next arrow that you see on your diagram. Let's say that's a cross-claim. It's where one defendant is suing another defendant. By the way, a cross-claim could be one plaintiff suing another plaintiff or a third-party defendant. It can get as complicated as you want. But cross-claims are between parties on the same side of a particular V. So are cross-claims permissible? The key thing to remember in cross-claims is the first cross-claim has to be related to the plaintiff's transaction or occurrence. In other words, the transaction or occurrence underlying the plaintiff's suit. Okay, the first cross-claim. After that, it's no holds barred, right? No holds barred. What do I mean by that? It means after the first one's related, the person who filed that first one can add on 3 or 4 more, even if they're not related. Can add on 7 or 8 more, even if they're not related. Well, where does it say that? That is simply an application of the multiple claim rule that we talked about at the beginning. You can bring 25 separate claims against the other party. That's the rule. You can bring as many as you want. But the one thing on cross claims is they have to be opened up with a related cross claim. It has to relate to the plaintiff's claim. Suppose the party responding to a cross claim has a ton of claims. Can he bring them? Yep. How do I know that? Because that's a counterclaim against somebody. Anytime you're returning fire to somebody who just sued you, whether you're a co-defendant being sued or a third-party defendant being sued, that's a counterclaim. And what did I tell you about counterclaims? You can always bring them, although sometimes you must. So even co-defendants sued on cross-claims sometimes have to return fire. But if they have a bunch of other extraneous claims, they can throw those in the mix as well. Finally, that arrow going to a third-party defendant. Is that arrow permissible? It's called an impleader claim. The key inquiry that you want to look at is whether or not that claim is essentially one for contribution or indemnity. Now, the language of the federal rules say you can implead someone when you are alleging that they are responsible for some or all of the liability the plaintiff is intending to impose on you. That's a little laborious. Okay, how about this? Because it's the case in almost every impleader action. You are saying, hey, you didn't get sued, but you helped me commit this harm. You need to join in the action. So there will be another V added to the lawsuit, and this other party will be added in. So it's an extra claim with an extra V in it. So as long as the claim is for contribution to a joint tortfeasor, no problem. Federal rules say that's okay. Now, in addition to contribution, you can also bring an indemnity claim. What's an indemnity claim? It's a claim against somebody who has agreed to insure you. So a lot of times it's an insurance company, but it could be anyone who says, listen, if anything goes wrong, I'll cover the costs. That's insurance, right? So if you're suing an insurance company or any insurance entity that's provided insurance, or you're seeking contribution, that arrow, you can bring it. Finally, what happens to that person who just got brought in? Well, we know that person can respond with counterclaims of any sort they want, because that's what the rule is for counterclaims. And we know that the one thing I haven't mentioned yet is the plaintiff. The plaintiff to that impleaded defendant, that third-party defendant just dragged in, the plaintiff is actually allowed to bring a claim against that party, but only if it arises out of the transaction or occurrence that underlies the plaintiff's original claims. Okay, so you've diagrammed everything out. You've got all these arrows. You label them cross-claim, impleader claim, counterclaim, and then you apply the rules for cross-claim, impleader claim, etc. Great. You have just solved a joinder of claims issue, but you may also have to tackle a joinder of parties issue. So, how do you do that? You do it roughly the same way. You've already diagrammed out the lawsuit. You've got all the D's diagrammed out because you had to figure out cross-claims. You look at that same diagram, and for each party in the lawsuit, you need to know whether or not it is supported or permissible according to a federal rule. So what exactly do you have to pay attention to? You really only have to pay attention to two different things, what I call stacked parties or third parties. Stacked parties or third parties. Again, the primitive lawsuit, P versus D, one claim, right? That is permissible under actually the most basic of federal rules. It's almost implicit in the federal rules. You probably couldn't find it statutorily explicit, but rather implicit. Suppose, however, you say, I want to sue two defendants, not one in the same lawsuit. Two people beat me up at the bar, and I want to sue them both. I don't want to bring two separate lawsuits. The federal rules say you can do that, right? So when you look at the diagram, it's P versus D and D. Those D's are stacked. What I just call stacked. It's in a line, 2 or 3 or 5 or 10 on top of each other, right? Could have been a really bad row at the bar. 10 of these guys can be sued all at once. Whether you can stack all those defendants together or if a bunch of plaintiffs went together, right? It's a huge melee at the bar. 25 plaintiffs want to sue 25 separate defendants. Can you do that? Yeah. The federal rules, you can do that under the following conditions. First, the plaintiffs claim relief or the defendants face liability, all arising out of the same transaction or occurrence. Right? So a bar brawl is a perfect example. All of our claims or all of our potential liability arises from that crazy fight last week at the bar. Okay? Also, the claims all have to involve, not the claims, the parties all have to seek relief or face liability involving common questions of law or fact. Common questions of law or fact. So, as long as you got that, and frankly, it's really easy to show, it's okay to have stacked parties. So you've done your diagram. If you see stacked parties, you run your stacked party test. All right. Next, you look for third parties. Third parties is that impleaded party. If you see an impleaded party, you do your third party test, and I've already told you what that test is. It's contribution or indemnity. If you're bringing a contribution or indemnity claim, no problem. You've satisfied the third party test. Now, the reason why I cover it here is because that impleader claim, you're adding a new claim and a new party. So it's technically joinder of claim and joinder of party. You're almost done. One last thing. Just because joinder's okay doesn't mean subject matter jurisdiction is okay and personal jurisdiction is okay. I mentioned that before, but students miss it all the time. So we're not tackling SMJ or PJ in this episode, but don't forget, those can be relevant. I wish you the best of luck tackling these joinder questions to the ground. Good luck to you.